Hi, everybody. Wanted to take a chance to welcome you to today's program. My name is Nathan Platt. I am the Western Pennsylvania Association of Corporate Counsel Vice President of Programming. I'm also the President-elect for 2021. I want to thank everybody for participating remotely. I know that the past few months have been challenging for a lot of our company clients, our friends, colleagues, and families. So I want to take a moment just to acknowledge that and thank everybody for doing the jobs that we do as counsel to try to give our clients great advice during the normal and sometimes during the abnormal or the new. Today we have a great program. I'm really excited about hearing from our presenters. The Gowling law firm, it's an international law firm that's a sponsor of the Western Pennsylvania chapter. They have put together a program on force majeure topics from an international perspective. They've got speakers lined up from China, the UK, and Canada. We are spanning really across the globe right now. This is a worldwide topic, a worldwide pandemic, and this is very timely for all of our companies that we represent. A couple of housekeeping items, just real quick before the panelists and presenters start. You should have received in your email a CLE registration form. This is a typical form like we normally have for our programs, the one where you sign it and fill that out and maybe do a commentary on how the program went. As a part of our kind of check-in, since we're not doing things live, we will be giving out 3 codes during the presentation. So I'll be kind of jumping back in and letting the group know that there's a code coming. If you can write those codes down, that will be good, because when you fill out your CLE form, there's a spot on the form that you sign and submit where you'll write the code down. And that's how we kind of track your attendance. So with that said, if you haven't got a form emailed to you or forgotten in your spam account, you can always email Barb at the Association of Corporate Counsel email, and we'll get you that form. Just try to write down the code and let us know if you have any problems. So with that, I want to just say, again, thank you to the Gowling law firm and the folks that have put together this presentation. It's going to be a great topic, and I'm looking forward to hearing from it. I'm going to sign off now and let speakers start, and then I'll rejoin back in along the way to hand out some more codes, maybe at the end. So thank you very much. And just to start things off, the first code for your CLE form is 6783. Code 1 is 6783. All right, thank you. I'll turn it over to Gowling.
Thank you, Nate, for that introduction. We're very grateful to be here today, albeit remotely in these strange times. My name's Catherine Nayor. I'm a commercial litigator in Gowling's London office, and I help clients to navigate through disputes, corporate commercial disputes, including contractual disputes, which is what we're going to be talking about today. And I'm joined by Thomas Timmins, who's a partner in our from Canada, and who's going to speak all matters Canadian, and Vivian Desmonts, who is going to talk from a China perspective. So Tom, Vivian, over to you to introduce yourselves.
Okay, well, hello everyone. I'm Vivian Desmonts. I'm a European lawyer, French lawyer. I've been practicing in mainland China for almost 20 years. I'm working from our Beijing office. I'm a partner at Gowling WLG. And I'm more of a corporate and international trade lawyer, so working regularly on cross-border transactions between North America and mainland China. Thank you.
Hi, everyone. Thanks, Kat. Thanks, Vivian. And thank you, Nathan, everyone in the Law Association of Western Pennsylvania for having us. So my name is Tom Timmins, as Kat mentioned. I sit in Toronto, Canada, and I lead the energy group at Gowling WLG Canada. I'm also heavily involved and actually technically leader of the China initiative in Canada as well. And we have been dealing with force majeure and international product challenges since late January, as I'm sure many of you have as well. So back to you, Kat.
Thanks, Tom. Actually, I think the person who's going to start off on the subject of force majeure is Vivian.
Thanks.
Yes, with pleasure. Thank you. Thanks to everyone. So force majeure, actually, as a French lawyer, I'm glad to confirm it's actually originates from French law, which is, as you know, France is a civil law jurisdiction. And mainland China, where I've been working since 20 years, is also a civil law jurisdiction. And it also recognizes this legal concept of force majeure. And so legally, in Chinese law, but also in most civil law jurisdiction, the law and contract law actually provides for a definition of force majeure. And then it provides for at least 3 legal conditions for an event to be recognized as force majeure under Chinese law. So basically, you have the first condition whereby a force majeure event, in order to be recognized by courts in China, force majeure must be, just my notes. It's an objective circumstances that cannot be foreseen by the parties when they concluded the contract. And then the second condition provided by the law is that this kind of event cannot be avoided by the parties, must be external to them. And then most important condition, the third one, is that this event cannot be overcome by the parties. So you can imagine that recently, COVID-19 pandemic, and especially the Chinese governmental measures on lockdowns and shutting down factories since February in China, these was, well, naturally events that could be considered as force majeure event, and the party which was prevented from performing its contractual obligation could claim force majeure event and either try to terminate the contract with its counterpart, or to have its obligation partly waived. And so we have seen a lot of cases since February in multiple sectors where especially Chinese suppliers negotiated and claimed force majeure against their own clients abroad, and claiming that it would prevent them objectively from performing their contract or to respect the delays. And we've seen many clients in North America, also in Europe, receiving, notifications from their Chinese counterpart, and sometimes even an official document from the Chamber of Commerce or the CCPIT in China, which recognizes that the COVID-19 was a force majeure event. However, force majeure in Chinese law and practice is not a free pass for a party to not respect its contract and try to early terminate it without any liability. No, under Chinese law and contract law, it is provided that the party suffering from force majeure event must be able to prove how this force majeure event actually prevented the party from performing its contractual obligations. And then what we have here in practice, and in most contracts also, generally international trade contracts would also provide for some more details in addition to the law for defining a force majeure event. And very often we would plan that the party and the force majeure event must get formal evidence from a notary public in China, not just a paper from Chamber of Commerce. So in practice, we really had to check the contracts, and since since this event, that there's also a lot of parties and companies abroad that are revising their contractual clauses, especially on force majeure event, and to plan for this kind of procedure later on. I think that then we can switch also to the UK to see how force majeure event is recognized under UK law.
I think I'm actually going to speak about Canadian.
Oh, is it Tom? Oh, sorry,
yeah,
Tom.
no
So
problem.
Canadian first. Very good.
Who's on first? Canadian law will, of course, be very familiar to most of the lawyers on the call. There are some distinctions, and I'm going to go through some of the basic principles. So the courts in Canada, and remember, Canada, not too different from the United States, is a federal state. So you're dealing with, in some cases, 13 different jurisdictions plus federal courts, and of course the Supreme Court. The law in Canada is, fortunately, it's one of those rare instances where it's actually fairly consistent across the country. Unfortunately, it's actually somewhat different in Canada than it is in the United States. So just to go back, the courts are going to take a look at a few kind of concepts. And these are concepts that if you're drafting force majeure or FM clauses, these are concepts that you'll very likely address when you're drafting. They're going to first look at qualification, whether or not the event qualifies as a force majeure event under the contract. And your perspective on that, of course, is going to vary depending on who you're acting for. So in the early days of COVID-19, back when we were still calling it the coronavirus and buying toilet paper, we found ourselves in the position where we, acting for one particular client, where we said, well, actually, this isn't a pandemic yet; it's an epidemic. And we haven't seen the World Health Organization take a position on this yet, et cetera, et cetera. So the question of qualification, and then what was a force majeure event in January or in February might no longer be a force majeure event in June. The world has changed quite a bit, and we've actually, to a certain extent, this might surprise some of you who are working in your upstairs offices at home, we've gotten used to coronavirus or COVID-19, and we're actually, and of course, in North America and the United States, we're dealing with other potential force majeure events that have become quite significant. So so what qualifies as a force majeure event is, of course, very, very relevant. Then you're going to be looking at the question of what standard, and this is where Canadian law differs from the U.S. law. What standard does the performing party have to meet, and whether we're talking about an impossible performance standard or whether the concept of commercial reasonability comes in. Then we're talking about foreseeability. Could you have foreseen this? Looking back at SARS and the MERS virus and all the various viruses that have come through the world economy over the past 10, 20, 25 years, looking back, we could actually say, actually, COVID-19 actually kind of was foreseeable. You could make that argument, particularly in Asia, where many of the Asian economies were prepared for COVID-19, much more so than we were in North America. And then the final concept that we look at in Canadian law is the remedy. Okay, fine, it qualifies. Okay, fine. Impossible, and the performance could not have been executed. Now what? What does that mean? Do we cancel the contract, or is there some sort of a remedy? So the courts are looking at those types of concepts. Leading case law in Canada, the key case is a company called the Atlantic Paper Stock case, and that's the case where in Canada we came up with what we call the impossible performance standard, where the party claiming force majeure needs to be able to prove to the court that it is not only impracticable, but it's actually impossible for them to perform. And that's where Canadian law becomes quite relevant. Other cases, Worldland, Atcor, Domtar are all important cases. Another case that's important is really the only case that we've been able to find where a COVID or corona-related virus comes into play, and that's a CRTC case that's colloquially known as the Sars Decision. Where one of our regulatory bodies in Canada actually grappled with the question of whether a virus could cause a force majeure event. Over to you, Kat.
Thanks, Tom. Am I right, Tom, in thinking that in Canada, force majeure isn't exclusively a creature of the contract, or is that not the case?
No, that's correct. We have force majeure at common law. So if it's excluded from your contract, you can still go to the court and claim force majeure. And of course, it's a species of contract frustration, and like they're on a spectrum in Canada. But if you don't happen to have an FM clause in your contract, don't give up hope. Although, I mean, even if you do have an FM clause in your contract and you're the party trying to seek excuse performance, it's an uphill battle.
Yeah. Okay. So that is slightly different. Well, the uphill battle I think is very similar, and I can come on to that in a second. Force majeure is not not an easy claim to make in England. Although I have to say it's easier than frustration, which we'll come on to in a moment. But by contrast to the position in Canada and in China and France, in fact, as Vivian outlined, force majeure is exclusively a creature of the contract in England. And so it doesn't matter which side of the fence you're on, whether you're if I can call it the contract breaker, the person who wants to get out of their obligations, or the person who's on the receiving end of a notice, someone saying they don't want to perform anymore, the force majeure clause has to be in the contract. If there is no force majeure clause in the contract, you have no possibility whatsoever of relying on force majeure. So the starting point in any force majeure argument, in practical terms, it sounds obvious, is to dust off the contract. What does the contract say? Because that is what will govern what will happen. So as you said, Tom, in practical terms in England, the first thing you would do is decide, well, has there been a force majeure event? And that requires you to look at what's happened in fact and what the contract itself says. And because contracts are typically negotiated, there's no one size fits all force majeure clause. You have to look at the precise words, and I'm sure the same is true in Canada. Now you might see a force majeure clause which has a closed list of events. So it might include, as you said, epidemic or pandemic. You often see acts of God like floods, hurricanes. You might have riots, civil unrest, that sort of a list. Now, if it's a closed list, obviously the circumstance which has occurred has to be in that list. And obviously you can have an argument about whether something is a pandemic or an epidemic. But if you're looking at a pandemic or an epidemic and neither of those are in there, then you will struggle to rely on force majeure in a closed list. But quite often, particularly in commercial contracts, you'll see a catch-all provision. So there might be, at the end of a closed list, it will say events or any other event outside the reasonable control of the parties. And so even if, certainly in England, even if your event isn't, a specific event isn't listed out, if you have a catch-all provision, any other event outside the reasonable control, provided it is outside your reasonable control, what has happened, then it would potentially constitute a force majeure event. So once you've decided, okay, it fits within the definition, it is a force majeure event, the next thing to think about is what has been the effect of the force majeure event. So has it prevented performance completely, or has it simply impeded performance, made it more difficult? And again, you have to look to the words of the contract. So if the contract says force majeure event has to prevent performance, that's a very high standard, as Tom alluded to. It's akin to impossible. So if you could perform the contract in a different way, but it would just become more expensive, that is not sufficient to meet the standard of prevention. You might have wording instead which talks about impeding or delaying or hindering, something similar. And again, it's very fact specific, but those sorts of words make it slightly easier, I suppose, to rely on force majeure than if you have the word prevent, because that is effectively an impossibility. So you have to look at the clause, and you have to look at what's happened and make a judgment call as to whether you can rely on it. I think there's a couple of other practical points on force majeure in England. The first is that you need to check your force majeure clause as to whether or not it requires some form of notice to be given. So some clauses are silent as to notice, others require notice to be given to the other party, if you're proposing to rely on force majeure clause, that is. One, the possibility arises that performance might be difficult or impossible, and sometimes a specified time period is included in the contract. Other times it may say you have to give notice promptly. But again, in England, because force majeure is a tricky claim to make, because courts prefer parties to stick to their bargain where they can, the notice provisions will be construed strictly. So if you don't give the required notice, or you don't give it in the form required, so it has to be in writing, for instance, delivered by hand, or whatever the case may be, then you might find, and it may sound harsh, but you might find that you would be prevented from relying on the clause at all. The second practical point is to think about whether there's another way that you might be able to perform a contract. So there may be some express provision in the contract to that effect, but even if there isn't, I think the English courts expect parties to use their reasonable endeavours to try and comply with what they promised to do if there is an alternative way of performing. But for instance, and I don't want to keep talking about COVID-19, but if, for instance, the government has decreed you may not attend your premises, then there is nothing you can do about that. There's no alternative way. If you're supplying goods that are there, there's no alternative way of performing. And I think the last practical point to check, again, Tom, you alluded to this, is what is the remedy provided for in the contract, in the force majeure clause? Does it give a right to terminate, for instance? Does it give a right to terminate if the force majeure event subsists for a period of time? And it's really important to look at that, because actually you may just want to be excused for a short period of time, but you really don't want the contract to terminate. You don't want to give rise to a right to terminate. So these are the sorts of things that you need to think about before you consider force majeure. Nate, I wonder if now is before we move on to frustration, Nate, I wonder if now is a good time to shout out your second CLE code.
I think it would be. So let me start my video, and if I can reappear for the audience. So the second code, and don't call bingo out if you win this one, but it's 8521, and that's second code is 8521. And then just to kind of remind the audience, there should be a Q&A component or a chat component where you can submit questions to the panelists along the way on your Zoom interface. We're going to have questions section at the end, but if you're thinking of things and you want to submit it to Gowling, that'd be fine. They can maybe get through as many of them as they can during the question section, and then we can always put people in contact with Gowling following the program. So that was code 2. I'm going to disappear again.
Thanks, Nate. All right, so I'm going to move on to frustration, which is the doctrine in England that you would be forced to rely on if there was no force majeure clause in your contract, because there is no common law force majeure doctrine here. So by contrast with force majeure, frustration isn't a contractual remedy, so you can only rely on it if there is no force majeure clause in your contract. What you couldn't do is say, well, okay, there's a closed list of force majeure events. The circumstance that's arisen isn't included in that list, so I can rely on frustration. Well, you can't. Frustration is it's what happens. The law will step in if effectively all else has failed, and for that reason, it is an extremely high standard to meet in England. In essence, it operates when something happens that's outside the control of the parties, but which makes performance impossible or so radically different from that which they promised to do that it automatically terminates the contract. So it's a pretty draconian high stakes decision. And the effect of it is that the parties are released immediately from any future performance, any obligations. And in England, as I think the position is elsewhere, there are a series of complex rules about how you deal with compensating parties who have, for instance, part performed or they've incurred costs in preparing to perform the contract. Now, I mentioned impossibility a moment ago in the context of force majeure, and in the context of frustration, again, it really does mean impossible. It doesn't mean more difficult or that performing will be more expensive. It means impossible. And when we talk about radically different, I don't just mean harder or of a different scale. It's not about hardship, which we'll come on to in a moment. It's about there being an event, a frustrating event that goes to the heart of the contract, that turns the obligation into something which is different from that you promised to do. Now, I know that's quite a dry statement of the law, much easier to understand with the examples, and I think Tom is going to talk about some practical examples in a moment, which will hopefully illustrate a little bit about what I mean. But hopefully you can see from that that in England, at least, it's really difficult to get an argument based on frustration off the ground. It's a high bar on force majeure, and there are lots of cases in England where frustration has been allowed by the courts, but not exclusively, but some of those are very old indeed. They go back to the 19th century. Much more recently, the courts have increasingly become reluctant to find that an event of frustrations occurred. And I think the prevailing wisdom is, particularly with two commercial counterparties, is if you wanted to provide for what would happen to your obligations in the event of something outside your control occurring, then you ought to have bargained for it. It ought to be in the contract. Now, I don't want to dwell on specific cases, but I thought I would just mention a relatively recent case on frustration, because we don't have that many, because it is such a high bar, and because we haven't talked about it for a little while. Brexit, it's a Brexit-related case, and in that case, the European Medicines Agency took a 25-year lease of a building in Canary Wharf in London, and it was, so far as they were concerned, being the European Medicines Agency, important that they were within the EU. But unfortunately, when England voted to leave the EU, they wanted to extricate themselves from their lease, and they sought to rely on frustration to do so. They said that the decision to leave the EU, it was a circumstance outside their control, and it was a frustrating event. Unfortunately for them, Canary Wharf resisted, and when it went to court, the court agreed with the landlord and said, actually, do you know what? The lease provides for all sorts of rights. So you have a right to sublet, for instance, you have a right to assign the lease. And in those circumstances, frustration does not arise, because it's not impossible. You could perform, you could sublet. Now they did get, I should probably add, the EMA did get leave to appeal that decision, but unfortunately they settled before it was ever tested in a higher court. But I think you can see from that it really is a high bar, and for that reason you can see why it's a high stakes decision. Because if you make the wrong call and seek to rely on frustration and treat the contract as immediately at an end, you put yourself suddenly, if that is wrong, you're the one who's in breach of contract. And in cases like the Canary Wharf case, but lots of commercial cases I'm sure we all deal with all the time, you could find yourself on the receiving end of potentially quite significant damages claim from the other side. So Tom, over to you to hopefully bring to life some of the slightly more dry topics I've mentioned.
Thanks, Kat. Vivian, I'm actually going to pass it to you just to give the perspective in China, if that's okay. And then I'll do my best to make it interesting with live examples, but don't count on it. Over to you, Vivian.
Oh, sure. Yeah, thanks, Tom. For the doctrine of frustration in China, mainland China, but actually also I understand in many civil law jurisdictions, it's not recognized at all by the contract law. So it's basically totally irrelevant on the basis of frustration or the fact that the purpose of the contract cannot be fulfilled. So I suppose it's back to you, Tom.
Thanks, Vivian. So if you don't have an FM clause in your contract in Canada, you're back into the world. I guess you can only see half my face here. You're back into the world of frustration. The seminal case on frustration is going to be familiar to virtually everyone on the call. I want to say on the phone, on the Zoom call, who went to law school in a common law jurisdiction, and that's Taylor v. Caldwell, 1863, Blackburn. And I think it's the best example to give, because there you had a case where a music theater was contracted in order to host a concert in 1863, and that theater burned down. And so it became impossible to host a concert, a music concert, in the theater, which no longer existed. That's a perfect example. It's the classic example of how frustration forms in a contract. Now, as Kat mentioned in terms of the Canary Wharf case, that can be worded around. I'm sitting today in a building, a vast building in downtown Toronto, which is virtually empty, but our lease still stands, and the building owner here still has an obligation to keep the building open, to keep the lights on, keep the HVAC systems working. Why? Because we've contracted for that as lessors. So the best example really is where the facility to perform the contract has been completely obliterated or removed. So government pronouncements may or may not meet that threshold. War, when we get into war and civil unrest, we get closer to that threshold. So a lot of the civil law doctrines that emerged in the 20th century came out of the results of World War I and World War II, and in particular in Germany, they came out of the consequences of hyperinflation in the 1920s, and I'll talk a little bit about that when we get into the doctrines of hardship. But when you're thinking about frustration, I completely would reiterate what Kat and Vivian said in terms of very high bar and very hard to meet, and you really have to have really good facts on your side if you're the party that's going to be seeking to successfully allege that and get the court on your side. And it's going to come down to really good facts. And having been on both sides of that in recent months, I can tell you it's a tough bar to meet. So. Back to you, Kat, I believe. Over to you, Vivian. We're going to discuss hardship.
Yes, thanks, Tom. So as I've mentioned, in China, we do not have the legal concept of frustration. However, if a party is in a difficult situation and cannot materially perform its contract, then if force majeure doesn't work, we may consider another legal basis here in China. It's hardship. Contrary to force majeure, Chinese contract law of 1999 or the law on the general principles of civil law back in the 80s do not provide for a legal definition of hardship. However, in practice, and especially when it comes to international trade operations, in practice, we would draft a hardship clause in the contracts, whereby if a party suddenly is under hardship and contractually we would define that by the fact that there's been an unforeseen and a major change of circumstances which renders the contract obviously unfair to a party, then the parties would need to renegotiate some adjustments to the contract. Sometimes also we would go into more details in the hardship clause of a contract. We would provide, for example, for some obligations of business continuity if there was a major change of circumstances, which would render the contract not possible to perform. So in practice, how is it recognized? In China, we do not talk about hardship. We talk more about a rupture of the principle of fairness. So this is based on civil law. And the Supreme People's Court has recognized this kind of special situation, which is not force majeure. It's really the fact that that there's a major change of circumstances, and would render the contract totally unfair for a party. So it's really up to a judge or an arbitrator in case of international arbitration. With some commissions here we have in the region, for example, in China with the CIETAC, or in Hong Kong IAC. The International Chamber of Commerce also has an arbitration commission here in China. In practice, when parties cannot renegotiate a contract because of this kind of hardship event, well, it's up to the judge or arbitrator to see if it's really unfair to the party under hardship. Kat, did you want to, or Tom, did you want to elaborate a little bit more on hardship?
Sure, I can give you the Canadian perspective. I guess the way to look at this is really to ask yourself, okay, circumstances have changed. Is there a duty on the parties or one of the parties to renegotiate? And then further, will the court step in? And if you think about this, and I think this is one of those cases where American lawyers and Canadian lawyers are going to be quite similar. Are you really going to be able to get a judge? And think about who judges are. Like they're having a hard time right now. And are they really going to step into your contract and want to sort out the differences between the parties and like work through what should be the contract terms in the context of current commercial realities? I'll tell you, in Canada, that's almost, you're just not going to be able to get the court to do that. The doctrine of hardship has not made the transition into general Canadian law. There was a recent case, and we're lucky to have a recent decision, Churchill Falls v. Hydro-Quebec, a 2016 decision that examined this. There was one dissent, there was a Supreme Court decision, there was one dissenting opinion on that case, but almost unanimously, the court came to the position that the doctrine of hardship did not exist at Quebec law. In that case, it's an interesting case, and if you're interested in any of the history of power production in Canada, that's a case regarding a 65-year long power purchase agreement between the province of Quebec and the province of Newfoundland in Canada, which has resulted in some public acrimony and dispute over the years. The question really, if the circumstances have changed, is there a duty to renegotiate? At common law in Canada and in civil law in Quebec, I would say no. That's, I think, different than some of the concepts in continental Europe, which in Switzerland, sorry, and in France and in Germany, where there are concepts arising out of kind of 20th century circumstances where there may be a duty to negotiate or where the courts may step in. You're going to have a hard time getting the courts to do that in Canada. Over to you, Kat.
No, I think the position in England is very similar. We don't have a separate doctrine of hardship, and in fact, the way if we're talking about hardship clauses here, we're really talking about a subset of a force majeure clause. So again, it's going back to the contract and dusting off the contract. Does the contract expressly provide that in circumstances where there's difficulty in performing, there's a right, perhaps not a duty, but certainly a right to renegotiate, or can you, is there an express amendment right? But it would normally, and typically in England, it would normally come somewhere under the heading force majeure. So it would be, one particular paragraph or subclause of your force majeure clause. You wouldn't, under common law, you wouldn't get an argument off the ground in England either, because it's just not, it's not recognised outside the contract. So you need to go to your contract. If the contract doesn't provide some kind of amendment right or right to renegotiate in circumstances of hardship, then I'm afraid in England it's probably the end of the road. And again, you're looking back to fall back on frustration, which is the common law, very much option of last resort, but it's there and it's available. So in terms of what we've learned and the future, Tom, I know you alluded earlier to if you're drafting a clause in January and you're drafting a clause today, what would you do differently? So what makes a good force majeure clause? What makes a bad one?
Well, thanks, Kat. Could you have 24 hours to talk about that?
In 2 minutes.
Yeah, 2 minutes or less. In terms of takeaways, one of the first things I would say before we kind of get to the idea of drafting, for those of you, particularly those of you who are in-house counsel, but if you're in any way kind of directly working with commercial folks in businesses, I would say the first thing to do, and you might want to write this down, is take action. So if you're receiving a force majeure notification, and what you'll often see is you might see a polite email or a letter even that's couched almost as a force majeure, it's kind of a quasi force majeure claim. You need to take action. You need to note when that was received and how it was received. You need to take a look at your notice provision in your contract. All right, and you need to kind of keep the context of the commercial context and the kind of the geopolitical context in mind. Force majeure clauses are really hard to rely upon. So if you're seeking to rely upon them, you need to act. then you're going to be going through kind of that whole step process. And I really want to emphasize, time is not your friend here. The other thing that's happening, well, if something's sitting on your desk or in your inbox on your computer, more likely, the world is changing and world events are changing. So the way we perceived COVID-19 in February and in March is very different from the way we perceive it now in June. And so things are evolving, and things are like just perceptions. And I would even say, go so far as to say, judicial perceptions of COVID-19 are very different now than they might have been back in March or in April. So that's the kind of the first key message I would leave with people is take action and make sure that you start to plan ahead for disruptions. And then the other thing that I would say that we took away from this, and we had a webinar, I guess it was in March, on this topic. And we had about 700 people on the webinar, which for Canada is incredible. I probably wouldn't have been able to get 3 people in a room to discuss force majeure last year. So it's become quite a topic. It's of a lot of interest. But the other piece that we did was we wrote an article about writing, and a lot of people were asking us, help us rewrite our force majeure provision. And kind of the best thing that we've seen has been the ICC Standard Clause that's come out, the International Chamber of Commerce Standard Clause that's come out. We did an article on that. Well, that clause is not, in our minds, it's not perfect. It's a really good starting place for drafting purposes. We wrote a piece kind of providing our input and our commentary on that article. And one of the things that we liked the best about that article, particularly if you think about it, in, like as of today's date, what's happening in the world. COVID-19 is important. There's also geopolitical tensions arising and trade disputes arising, not just between the US and China, but between a lot of different countries and a lot of different jurisdictions. And then, of course, there's civil unrest in the United States and in Canada and in other parts of the world. So the world, of course, is continuing to move along. What does that mean for your clause? I've become a really big fan of broad, general language in clauses that can capture. So you're probably not going to be able to list all future world events. In fact, you know you're not going to be able to, but capturing some themes, and this is what I think the ICC clause does really well, capturing some themes and trying to clearly state that test for that threshold as to when an event crosses the line from becoming a force majeure clause to, from becoming just an event to becoming an actual qualifying force majeure event is, I think, a really good concept. The other thing I would leave with people in terms of hindsight is make sure that your choice of law, so we've noted that there are differences in law, make sure that your choice of law provision aligns and works with force majeure. So if you're going to be relying on the law of New York or the law of Pennsylvania, what is the law in relation to force majeure, and how does it read, and how is it going to be interpreted? The law varies from the United States, from state to state. Within Canada, from province to province, there are slight variations. And then as you cross the Atlantic into the UK and into Europe, and then in China, or the law of Hong Kong or Singapore, there are a lot of differences there that really come to bear on force majeure clauses. So you need to, going forward, we all need to be really cognizant of that and how those clauses, including our notice clauses, which who would have thought, our notice clauses in our contracts, which are typically boilerplate, become quite important. So there's my 2 cents, Kat.
Thanks, Vivian. I'm conscious of time, but did you have any lessons learned?
I think based on our practice here and the experience of our clients doing business in China, and drafting force majeure clause or thinking about how to enforce the contract during difficult times, it's really also to be quite detailed in the contract on the procedure to gather the evidence, the proof of force majeure event or even hardship situation. So this we can really require from the other party that it provides, for example, a certificate by a notary public. In China, this is really the best proof that we can get. And then you would provide for a certain delay to provide this certificate or testimony. And then I would also advise to provide well, depending on the projects, but generally it would be good also to provide for a business continuity clause just after the force majeure clause. That means, as Tom mentioned earlier, we need to all plan ahead for disruptions. It's not just COVID-19. It is, as mentioned earlier briefly, it's also the US-China trade war. That there can be so many events happening this year and the years to come. So you need to plan ahead and try to see and provide in the contract what the parties should do when there is this kind of situation happening.
I think my my 2 pennies worth, probably keep it very short, as a disputes lawyer, is I think the future will hold a significant number of commercial disputes arising as a result of people seeking to rely on force majeure clauses and potentially on frustration. As I said earlier, I think it is a very difficult thing to do. It is a high bar, but I think parties are in difficult times are being forced to look at the force majeure provisions and decide whether they actually want to give notice under them. And if you get that notice, you look at it and think, actually, I'm not sure a force majeure event has occurred at all. I'm not prepared just to accept it. And I think it will remain to be seen whether, given the duration of this particular, I mean, as Tom said, there's all sorts of other events in the world that could well be force majeure, but in particular COVID-19, it's been such a lengthy, disruptive event. It will be interesting to see whether the courts are ever so slightly more sympathetic than perhaps they would have been before to parties who found themselves in real contractual difficulty as a result. So I guess watch this space from a disputes perspective. So Nate, I think back to you, Nate. I think I saw on the Q&A flash up a question about the first CLE code, actually, as a starter.
Yeah, and we did put that back to that person privately who asked the question. We got a couple other things. Are we going to move into the kind of question and answer phase now? Okay. So first question that came in, I'm just going to read it off to the panelists, and you guys can all kind of weigh in with your thoughts. But recognizing that force majeure is fact specific, can you please address the general scenario where demand for a party's product or products has been destroyed following COVID-19? In particular, a situation where a party is not required to close its business. However, due to COVID, the customer demand has pretty much just flattened out. Can the party declare force majeure on its raw materials contracts, under the argument that COVID has destroyed the demand for its end products?
I can give you some perspective at Canadian law, if that's useful. That's going to be a tough case to fight if I'm the party trying to say that what I would call a material adverse change in market conditions constitutes a force majeure event. Well, unless I have a material adverse change, or a MAC clause, as we call them, in the contract, purely on the basis of common law, the change in market conditions is going to be really tough. And you don't really see force majeure clauses that take that into account in the Canadian context. So that in Canada, I would say that's going to be quite challenging, the market change. And that's exactly the type of scenario that has been discussed in some of the seminal Supreme Court cases in Canada, and where the Supreme Court has given a thumbs down to the party alleging that's a force majeure, that constitutes a force majeure event. That's the Canadian context.
Well, I think the position in England, I'm sorry for whoever asked the question, I think the position in England would be the same, actually, because what that is, in fact, is, I mean, it depends what the force majeure clause says, and as Tom said, if there's express provision for that particular event, I'd be surprised. Certainly, it would not be a standard provision in an English force majeure clause. But I think the way the courts would look at it would be to say, your market's fallen away, what that doesn't mean, it doesn't create an impossibility for you to buy the raw materials. You can still buy those raw materials, so you can still perform your side of the bargain. You don't want to anymore, but you must, otherwise you will be in breach of the agreement. So I mean, I know that sounds very harsh, but that's the way the courts, I think, in England would treat that particular circumstance.
And for China, and as a civil law jurisdiction, it would be actually the same result. Especially in civil law jurisdiction, written contracts are really of the utmost importance, and we need to normally respect the written contracts. So if it's just a change of mind from one of the parties saying, oh, but finally I cannot sell or resell the products in the US as the same price as I intended in the beginning when concluding a contract, this in China wouldn't be recognized as a force majeure event. Courts would basically say, well, no, this kind of reason is actually not external to both parties. It's actually really much related to the intent of one of the parties. So force majeure event wouldn't work, but in case of litigation or dispute here in China, we could certainly consider hardship and this principle of fairness, as mentioned earlier.
So what I took from that is, a very important clause that we may want to be thinking about as in-house counsel and adding them as fast as possible is the material adverse change in market conditions clause, because that's going to be easier probably to hang your hat on from a negotiation standpoint with the other side than it is to run to court and have a maybe fact-specific technical force majeure proceeding.
Well, and of course it depends, Nate, because remember, as in-house counsel, I'd be willing to bet that you have, both customers and suppliers. So you're kind of looking in two different directions. You don't necessarily need to be consistent looking in those two directions. You might want to have a lot more flexibility with your customers than on your own behalf than you might with obviously from your suppliers. You might be a tough cookie dealing with your suppliers. I expect you are, Nate. So,
well, I try to be with a smile on my face.
Good.
Okay, so just before we get into some more questions, I'm going to take a moment to give out the final third code for the CLE credit. So this is code number 3 to write down for the audience who are applying for CLE credit, and that code is 3564. 3564. And a few more questions have come in as well. Let me bring those up and read them off to the group here. So another question that came in from a panelist, an audience member, was how often should a corporation change their force majeure clause, generally? As more and more scenarios arise in which force majeure may apply, adding these clauses could be burdensome. Or should force majeure clauses just have a catch-all at the end of the clause, as discussed?
Oh, you might be on mute, Kat.
Sorry.
Oh, you might be on mute. Oh.
Yeah, no, yeah, strange. Sorry about that. I think it's a good question. I think the lawyer's answer is it really depends. It depends what side of the fence you're on, doesn't it? As to whether you may want to rely on the force majeure clause or not, whether you should have the catch-all language. I think some kind of catch-all language is sensible because, as I think Tom said earlier, it's impossible to list a definitive set of all possible events that could constitute force majeure. The important, I think, point about catch-all provision is that it has to be outside the reasonable control of the parties, so it's not a get-out-of-jail-free card. But as to how frequently you may want to dust those down, I think it's good practice to look at your standard terms and conditions periodically. And I think, I wouldn't say, and forgive me if either Tom or Vivian you disagree, but I think suggesting to do it on any kind of time basis may not be practicable. I think just if world events have shifted the needle a little bit, you think you may want to, you may need to look again at what constitutes force majeure. I think I think probably if there's a big predicting more disputes, if there's a big decision in your jurisdiction on force majeure, then you need to look back at your force majeure clause and see whether some amendments are required in light of that decision. But I think just good practice is to look out your T's and C's every so often. But I wouldn't put a time period of every month or every week or every year on it. It kind of depends.
So in the news, there's some talk of maybe like a second wave, right? And that may be a second wave in the U.S. It may be a second wave in a European country or an Asian country. Should we be thinking about, like, if a second wave happens, we can get out of this contract clause?
That's interesting. That's and I'm sure Tom, Vivian have some thoughts, but it seems to me to be similar to some of the Brexit clauses we were seeing sneaking into contracts, where people were trying, before the decision was taken as to whether or not the UK would leave the EU, parties were trying to provide for, well, what will happen if the decision goes this way, what will happen, and trying to contract for it. But it's very difficult to contract for something where you don't know exactly what's going to happen and what the consequences will be. Tom, did you have something? You look like you were very keen to add something.
Don't get me started. So the ICC clause does a really good job of addressing this. Basically, the way it's structured is it kind of has an opening paragraph that says force majeure means the occurrence of an event or circumstance that prevents a party from performing one or more of its contractual obligations, where that party proves impediment was beyond its reasonable control, the impediment could not reasonably have been foreseen, and the impediment could not reasonably have been avoided. And then it goes on to say, in the absence of proof to the contrary, it lists, you can list a series of events that would be, included but not limited to, your war, riot, civil unrest, currency, trade restrictions, those types of things. So I like that you've got a basket clause that's built into kind of a high concept 3-point test. And then, of course, in each and every one of those points is that brilliant and wonderful common law word reasonable, which functions really as a demilitarized zone between the parties, so that everyone's a little bit uncertain what the court's going to do, and hopefully that keeps them back from the foul line a little bit, and hopefully they can resolve their differences without having to go to the courts. So that's kind of my 2 cents as a contract drafter. Vivian, I don't know if you have any thoughts to add on that.
I suppose so. It very much depends on when the contract has been concluded. If you conclude a new contract now after the first wave of COVID, then the second wave of COVID could be considered somehow foreseeable. What is not foreseeable is the extent of the Chinese governmental measures, shutting down factories. For how long? Would it be just 2 or 3 weeks? Is it going to be 2 or 3 months? This is not foreseeable. Whether reasonably or not, this is not the test in China. It's just, is it foreseeable or not during the conclusion of the contract? Yeah.
Okay, thanks. And another question that came in from our audience participants relates to kind of the leasing space that we're all doing. I mean, I'm broadcasting from my blue room at my house. So the question that comes to this: what about changes to leases for office space? If more people or all people work from home at a company, any way of getting out of these leases? Frustration or purpose, we don't need it anymore. The purpose was to house people in there. It's not necessary, or people were recommended to stay home now. I mean, any thoughts on that topic?
I think in England, you'd certainly struggle with frustration, I think, in view of the Canary Wharf case I mentioned. I think it is difficult. I mean, we have circumstance at the moment in England where landlords are not able, I think, to actually evict non-paying tenants. I don't know how long that will go on for, but at the moment there is landlords are facing some difficulties where they have tenants who can't or won't pay, but they're not able then to evict them. But I think in terms of frustration, it would be very difficult because you might be able to assign the lease, you might be able to sublet, and I don't think it is impossible for you to occupy for the period of the lease. I think certainly in England, I think it'd be difficult.
Okay, so we're stuck in those leases.
There are lots of, there's always, I don't want to say this, what I sometimes say, if you look at your business card long enough, you can find a spelling mistake, right? So
yeah.
There's always a way. The thing about commercial tenancy law is that it's a very mature and well-trodden area of the law. About 1,000 years of case law there. It's a very mature area of the law. But it's worth looking at. I know a lot of parties are doing that because a lot of companies are pivoting, and whether they have sublease rights, whether they can let go the shell company that they used to sign the lease, whether they can renegotiate extended provisions, things like that. It's something that I know a lot of parties are looking at in Canada, at least, and that's just on the commercial side. Vivian, I'm sure you're dealing with the same thing in China.
Yes, in China, it's the same. It's very difficult to get out of a lease contract, even amid the COVID-19 situation. What we have seen actually in practice since February is actually the Chinese government providing some subsidies, and many companies are waiting for subsidies of the government in Hong Kong as well, also in the current times. And for example, in China, when the landlord is a state-owned enterprise, the central government actually ordered that rentals for February and March would be totally waived or partly waived, depending on the cities, because then it was the government ordering all state-owned enterprises to waive rental for their tenants. But in the private sector, private landlords generally didn't grant any waiver or didn't reduce the rentals. So what did some companies do when they were in dire financial situation? Well, they basically early terminated the lease contract. In practice in China, lease contracts are really relatively short term, even for businesses. It's like 1 to 3 years, sometimes 5. Okay, so then some companies basically make the calculation and they say, well, if I early terminate, okay, what am I going to pay as penalty? Is it still better than continue paying the rental for such a large space for the rest of the term?
Okay, thanks. And just keeping with the timing of things, we'll just do one quick question, and I'm going to pick from the other ones in here. But just is there more room to argue that COVID-19 was a force majeure event, or was not a force majeure event?
Depends who your client is.
I have for China, I have maybe one quick answer. Actually, is the Supreme People's Court itself published an interpretation in March, basically saying that it's not the epidemic which should be considered as force majeure event. It's more the governmental measures, control measures that were adopted, and the fact that factories were basically ordered to close down for unlimited period of time. Back in January, February, and even until March for some parts of China.
I think in England, it depends what your contract says, of course. But at the beginning of the news reports of because we were slightly behind in terms of locking people down, but in view of some of the reports of other jurisdictions doing so, some commentators were suggesting actually, if you have a force majeure clause which talks about pandemic or epidemic, but actually it's not the pandemic or the epidemic that's causing the force majeure event, the force majeure event is actually the government lockdown. Well, in that case, I don't think COVID-19 would be a force majeure event. I think I think probably that softened a little as to how long it's gone on. And as I alluded to earlier, I think in England, if you had pandemic or epidemic in your force majeure clause, if you had government lockdown, I think there would be relatively little sympathy at the suggestion that actually COVID-19 is not a force majeure event in those circumstances.
Well, I appreciate everybody jumping on. This was a great topic. We did have another just final kind of wrap up question come in from the audience about maybe if we could send out a copy of the article commenting on the ICC model clause that was referenced, and we can do that as a follow up to the ACC Western PA membership. The other thing too, folks, because I know we kind of went over a little bit, but we have Gowling's folks standing by if you want to reach out to them privately. We can make sure that you're connected to to Tom or Vivian or Kat. If they are not in the jurisdiction that you're thinking about, I'm sure that they have other folks in the regions that you might need help on. We're all trying to figure this out as we go. I never thought we'd be going through a pandemic trying to practice law and figure out what the law means. And to Tom's point back in the beginning, force majeure clauses were just kind of like, well, maybe my building might burn down because of an earthquake or something, but I'm not too concerned about it. But I think now everybody is. So again, I just want to say thank you very much to the Gowling law firm, Vivian, Thomas, Kat, Joy, all the folks who helped put this together. It was a great presentation, and thanks for attending. And please feel free to reach out to Gowling or the ACC, and we can make sure that you have the connections to get what you need in terms of counsel and representation.
Thank you, everyone. Thank you, Nate.
Thank you. Thanks very much.
Cheers, everyone.
Everybody.
Bye-bye.